I'd like to share with you a little bit of my experience as a UN working group on enforcement management system. Okay. We just finished our session in September 2021 in Geneva, and actually, he was also there as a member of a committee on enforced disappearances, which is a treaty project. Mine is a UN charter based, but part of the special procedure. So I will start with my introduction to this working. As you know, in UN human rights system, there are three groups of human rights mechanisms. One is the UN charter-based mechanism. In other words, all UN members are subject to jurisdiction of this mechanism. By treaty body generally deals with the countries where the country has ratified. And this working group with all these special procedure mechanisms that is established in the Commission on Human Rights in 1990 after the Cold War and a lot of disturbances and we rely on declaration on protection of all persons from enforced disappearances. And we also have a method of work. Currently, we have a 5 members. As you know, special procedure consists of 3 different types. One is a special rapporteur. This initiates a very more the UN Human Council established special rapporteur. And independent experts are sometimes referred to if the issue is newly developed and not widely supported as a topic of special rapporteur. On the other hand, if the issue is big, and for one person to develop a established working with generally 5 members, my working group, along with arbitrary detention, business and human rights, and some of those issues are covered by working. And all of these 5 current members are elected through 5 different regional institutions. And my term, I started in 2015, and my term will be over next year. So, and I'm looking forward to conclude all of my 7-year experience. Enforced disappearance itself, to some people are new concept, especially living in the United States, do not understand how serious problem this is. But we, in our database, had registered more than 8,000 cases last 4 years. And unfortunately, out of those, 46,000, more than 46,000 still not clarified that continue. So this is huge kind of problem. And when we talk about enforced disappearance, we focus on 3 elements of constituent elements. Actually, enforced disappearance is considered as international crime, and the elements of those crimes include the first part, deprivation of liberty against the victim's will, and secondly, governmental involvement in some way, either directly or indirectly, or at least in excess of the government officials or the government involvement, some disappearance should have been committed. And finally, the government denies the acknowledge the fate or whereabouts of the fact that they have the person in the case. So these 3 elements are common both for the working group as well as committee, which is a treaty body under the International Convention on Enforcement. And to help you understand a little bit further, actually, out of 6 UN fiscal organs, there is no Human Rights Council as a fiscal organ, but UN General Assembly established the Human Rights Council in 2006 as a under the UN General Assembly as a subsidiary body. And Human Rights Council has a very important and big procedure, which is the Universal Periodic Review and also special procedure. And Universal Periodic Review reviews all of UN members' human rights record every 5 years. And special procedure is a kind of also developed in a very systematic way in 2006, where country mandate and the thematic mandate were created and are being created. And currently we have 57 special clusters, 14 focused on country and 23 focused on other thematic mandates. And altogether we have around 80 mandate holder experts in the Human Council special clusters. My working group is more kind of toward the humanitarian function when it comes to individual enforced disappearance cases. So we try to assist family members to locate the fate or whereabouts when a person actually disappears. And as you know, in many countries, when a person disappears and when the government is involved, the government seldom cooperates. Sometimes looking for the whereabouts is an issue, and that they may subject to threat and other attacks. So once the case is registered to the main system, at least they are more empowered. And also, we try to establish a channel of communication between the family member and the government. And as you may know, like in Egypt, many of the disappearances, short-term disappearances, actually are registered through our system. And if their case is in the system, and when we start to communicate, at least the government is starting to trace where the person is, even if it is done by security agent or some really who enjoys that culture of impunity. And those are kind of sometimes safe and at least helpful for those victims, especially when the government and all the special institutes in the government control do not care much about the legal procedure and others. And we see our environment sometimes state life. In many cases, at least people are involved but consider when is or really important because they do not trust police, security agencies, or military. We also do document cases, investigate, and monitor the practice of enforcement and try to address the issue with when it comes to a case method, we deal with a case procedure. But if it is a case that has committed within 3 months, very recent case, we go urgent procedure. So even if we are not in session, our members receive the email and we process the communication and send it to the government. And this urgent procedure is really complex. And like in Turkey, Khashoggi case, within a week, we receive the case. These are very, very important procedures. And also, with the older cases, or the not urgent, we use a standard. And in handling, we try to clarify case by locating the date and whereabouts. But sometimes, or some number of cases are not. And I think that someone is yes, open the microphone. And so additionally, we also have some other general procedure like urgent appeal, which is could be done by my working group alone or along with other special efforts or other working groups and other agencies in the form of joint letter and prompt intervention, general allegation. When a case is not dealt by individually, we come up with some general allegations so that the government can respond and find out a way to address the issues. So a lot of kind of creative method we are developing. And we have 3 sessions a year. And generally 2 sessions are happening in Geneva for around 7 to 10 days. And 1 session is happening in each region of rotating. And during the session, we coordinate among members, meet the governmental delegations, civil society organization, victims, and other UN agencies. So these 7 to 10 days are really important. When I was first, appointed to this membership, actually Bernard was there already. He was the one who comes before me, and he told me that to become a member is not a big deal because you will travel around 2 weeks, once and 3 times a year, and very low kind of work load you will see while tremendous. That's why I believed it, and I did actually apply, and it's selected. But even if the UN says you will work for 3 months full of work per year, in reality, it's more than I think half of my all work. So this is huge commitment, but really the working process and the working session is actually starting point of all. And some of the sessions, as I said, was happening in the region, and the one session in 2019 was happened in Bosnia-Herzegovina. And as you know, in this Srebrenica camp, there is a monument, and take a look at the names. All of the last names are the same. People or villagers living there were all killed together. Unfortunately, when I visited the Jeju Island massacre site in South Korea, I saw similar thing. All last names. So, Enforced Disappearances, massacre, and other, less humanized violations shows a lot of. We do country visit to enhance the dialogue between the victims, government, and also to learn the patterns of enforced disappearance to other victims. And the examples of our country visit here in Ukraine in 2018, we had a 10-day country visit. And during this mission, as you know, Crimea was occupied by Russia, and Donetsk and Luhansk region was also occupied by rebels. Very sensitive position. And we knew that enforced disappearance was committed by both the government as well as rebel groups. But UN does not have authority to cover non-state actors, and we are trying to expand it in a way or another. And so these are very challenging issues. And we traveled to Ukraine, starting from Kiev, Supreme Court, met Supreme Court judges. Next, there was the same Castro. We couldn't go there. We were too busy with work, so only I took one picture. And we moved to conflict zone. This beautiful Ukraine, thing, but in reality, there were artillery coming in that war was still going on. We were crossing the war zone with armored vehicle, with helmet and everything in our vehicle. And as you see the building points, after the visit, we immediately released our preliminary operation saying that during the conflict, both parties had a committed approach to experiencing. They showed that their obligation and international human rights were. Because of lack of time, I will just go quickly within a minute on Sri Lanka. So in Sri Lanka, there had been war for 30 years, and Rajapaksa, former president, ended the war with a lot of enforced disappearances committed under his regime. Sirisena, who was a former colleague of Rajapaksa, became president and invited the UN, and we went there. And during our visit, we found that for 30 years, more than 12,000 cases of committed, enforced disappearance has been committed, some of which are against the student movement in Sinhalese part, governmental part, and others were by Khalid Tiger, and some of them are so-called white band. And you see here, again, the beauty. So I departed from Hawaii, this beautiful city, to go to Tamil. It's really kind of a traumatic process. Bernard and other people went there, and you see in Sri Lanka, people were still looking for their family, their husbands, their sons. And in one city, we saw almost 400 people waiting for us, not 400, more than around 800 for 4 hours. And one lady told me that she knew who kidnapped her husband. And on the day when she came to meet us, that former police said to her that I know where your two kids are today. They're in school. So they're still tracking, even for her victim. We met President, Prime Minister, and Navy Commander and others. And we eventually visited the underground dungeon prison facility. And then I was there, and we found these walls, which were really not investigated until we pointed out. And then we found later on a lot of bodies and a lot of disappearances. And this is one of the prisons where 3 people were still in prison, but before that actual visit of the solitary cell, the beautiful vice warden presented that there is nobody in that section, but we found there, and those 3 people have never met any lawyer for the last 7 years. So huge problem, and it became international. During the visit, Sri Lanka released the 21 political prisoners. They joined promised to join committee and the Convention on Enforced Disappearances. And however, unfortunately, Sri Sena lost his power. And Rajapaksa became prime minister, and his brother is now president. And Sri Lanka is correct. I'm really worried for many of those people who are still suffering, who are still in interest. And I will stop. Thank you so much.
And in the interest of time, I will welcome the Professor Bernard Durham for his presentation. Bernard Durham will discuss the development of international human rights law related to enforced disappearances, addressing in particular the recent history of the UN Working Group on Enforced and Involuntary Disappearances, its doctrinal contributions, as well as the impact that it has on both international and domestic law and institutions. He will also analyze current obstacles and challenges in the field. Bernard Durham is a full professor of law at the University of Quebec in Montreal and former member of the UN Working Group on Enforced and Involuntary Disappearances 2014 to 2021. He is currently fellow at the Pierre Elliott Foundation and the Geneva Academy, a visiting professor at Paris II University, and avocat émérite, senior counsel at the Quebec Bar in Canada. He graduated from the University of Notre Dame LLM program in 2002. Please welcome Professor Durham.
Good morning. Good morning. Can you hear me well?
Yes, perfectly, yes.
Okay, excellent. So thank you. Thank you, Jean-Marc, and all of you for organizing this fantastic event. It's a real honor to be among you. I wish I could have been in person, but as we say in French, ce n'est que partie remise. We will do it at some other time, I'm sure. So as it was said earlier, I studied where you were 20 years ago in 2001. For some technical reason, the graduation was in 2002. I was then studying with Taeyong, who was doing his PhD, and we were able to work again later at the Working Group on Enforced Disappearances. And Juan Pablo Albán, who will speak after me, was a colleague of mine at the Inter-American Commission on Human Rights. So I'm extremely pleased that our paths as fighting Irish human rights defenders continue to cross, and I'm sure that our paths and yours will continue to cross as we share these experiences. So I will address quickly contributions of the working group to the development of human rights law norms and institutions. I will then discuss the relative efficiency of these norms and processes, and then talk about obstacles, challenges, and current issues. So firstly, when we look at the working group's contribution to human rights law, we have, of course, to acknowledge that the creation of the working group in and of itself in 1980 is quite remarkable. It was set up essentially because of the pressures that were made by families and relatives of victims, essentially from Latin America, who pushed the then Human Rights Commission to create a working group on enforced or involuntary disappearances. It forced the commission to address the topic. It also forced the commission to create a humanitarian procedure where, as Taeyong Baek discussed or mentioned earlier, there's an exchange of information between the relatives and the states. Now, this is particularly innovative considering that at the time, very few states had ratified treaty-based, treaties, human rights treaties, and recognized the competence of treaty-based human rights mechanisms. So there was very little that existed at the time in terms of submitting complaints to the UN. Then, of course, the work of the working group has influenced considerably the international jurisprudence in several important cases, including the major case of Velázquez Rodriguez versus Honduras, which I'm sure you have read, which refers to the work of the working group and the current development at the time. But it has influenced cases all along the history of human rights law, in particular with respect, for example, to the right to truth in many of the Peruvian cases that the court developed about 15 years ago. Of course, the working group's activities have influenced the negotiation and adoption of the 2006 Convention on Enforced Disappearances, and later the creation of the Committee on Enforced Disappearances, of which Juan Pablo Albán is a member. I'm sure he will address this a bit later. It has also, of course, influenced the drafting of the elements of crime for the ICC statute, the Rome Statute on the International Criminal Court. As you know, Article 7, which provides for crimes against humanity, recognizes the crime of enforced disappearances when committed as part of a systemic and massive attack against the civilian population. Currently, there is discussions about enforced disappearances by the International Law Commission as they are elaborating an eventual convention on crimes against humanity. The working group of the UN has in fact submitted a memorandum to the Human Rights Law Commission to present its own position. Now, these last developments regarding the ICC statute and crimes against humanity are not surprising, considering that the issue of enforced disappearances is one of the first human rights issues that has really drawn bridges between human rights law and international humanitarian law. In the history of the working group, as you probably know, the first instances where these types of crimes were documented were during the Justice and the High Command trials that took place in Nuremberg with respect to the Nacht und Nebel's decree that the Nazi regime had adopted and provided essentially for enforced disappearances. And starting from there, discussions both in international humanitarian law and international criminal law, as well as human rights law, developed. The working group has traditionally, as other special procedures and treaty bodies, adopted general comments, which are essentially observations or interpretations of the 1992 Declaration on Enforced Disappearances, which is a General Assembly resolution, its main instrument of work. So it provided a series of interpretations of specific articles and topics, especially regarding the obligation to detain individuals in officially recognized institutions, the nature of a crime of enforced disappearances, amnesties, pardons, crimes against humanity, the right to truth, the right to legal personality, and so forth and so on. Now, since I joined the working group in 2014, the shift towards which occurred was to concentrate less on observations or comments related to the declaration, but rather to focus on thematic issues. So there had been a special part of a report dealing with the best practices on enforced disappearances, and another one dealing with reparations. But since I joined during 2014 to 21, we addressed issues related to economic, social, and cultural rights, disappearances in the context of migration, as well as best practices in the context of international of criminal investigations, and more recently, in the last report of the working group, on transnational transfers. So these are very, very pointy, very specific thematic analysis of enforced disappearances in very complex international issues that are the concern of the international community. So these are good examples of contributions to the development of human rights law. I would say that thematically speaking, the working group's most important impact has been in the field of transitional justice, essentially thanks to visits that it did in different countries, most recently to Peru, Sri Lanka, Albania, and Gambia, addressing issues such as enforced disappearances as a continuing crime, amnesties, military tribunals, the use of non bis in idem in trials that do not respect due process of law, command responsibility, disappearances as a norm of jus cogens, the right to truth, the right to memory, the obligation to search, the right to justice, the right to reparations. Of course, there have been other very important developments in other fields of international law related to enforced disappearances. For example, the fact that when these disappearances occur, it's one of the few instances where tribunals will, in fact, recognize a violation to the right to legal personality, as was the case in the Gelman case versus Uruguay. Of course, there's been also very important impacts on the rights of detainees and conditions of the detainees, because the working group regulates in part the official nature of these detentions. So big impact on the Nelson Mandela rules, for example. I would say that practically speaking, the visits are those that have had the most impact regarding domestic law. The visit to Mexico has impacted the adoption of a law on enforced disappearances, a law on victims, the creation of a national commission to search disappeared persons. Similarly speaking, in Sri Lanka, the visit resulted in the ratification of the convention, the creation of the Office for Missing Persons. In Peru, the visit also was followed by the creation of a national commission on the disappeared persons, the consolidation of memorial sites, the exhumation of mass graves, and the strengthening of the legal anthropology or medicine sector. In Albania, the visit triggered the declassification of archives from the secret police during the dictatorship. In Gambia, the work of the working group has been used quite extensively by the Truth Commission, and the visits that took place in Ukraine put the issue of non-state actors and their relationship to enforced disappearances on the table, as well as the recent visits to Central Asia addressed transnational transfers, which were later discussed more thoroughly in the thematic report that I mentioned earlier. There are other external impacts of the working group's work, not just on domestic law. Let's, for example, think of the impact that the work of the working group has had on domestic prosecutions, for example, in Argentina and Chile, whereby domestic trials refer to the fact that there had been cases denounced before the UN Working Group on Enforced Disappearances. At the UN level, the work of the working group is being cited and used quite extensively in the Universal Periodic Review exercise at the Human Rights Council. Its work is also cited quite often by other special procedures that address indirectly enforced disappearances. For example, the Working Group on Arbitrary Detentions, the Special Rapporteur on Torture, Special Rapporteur on Arbitrary Summary Executions, the Special Rapporteur on Terrorism and Human Rights, and so forth. Another quite important element, which is often forgotten about with respect to the impacts at the multilateral level, is the fact that the working group serves as a record for humanity. While other instances across the world, including domestic instances, refuse to recognize the instances of enforced disappearances that are denounced by relatives and victims most of the time, the working group is one of the few places in the world where victims can actually denounce and have their case on record. And this might be used 10, 15, 20 years later in international or in domestic proceedings. So the fact that it's there as a record at the UN is quite useful. This is all quite interesting, considering that most of the work of the procedures of the working group as a special procedure are technically speaking more, of assisting states and providing recommendations, and not, generating hard obligatory norms or law. Now, this being said, we all know that enforced disappearances and the prohibition of enforced disappearances is now a norm of customary international law and is even a norm of jus cogens. So, of course, this has an impact on the capacity of the working group to refer to these obligatory norms when trying to convince governments to ensure better respect for human rights. Of course, governments will then deny the fact that these are enforced disappearances, as they do for torture or genocide and so forth, but at least there is a recognition, a worldwide recognition of the prohibition of enforced disappearances. Very quickly, and I'll stop with that, obstacles and current challenges. With respect to obstacles, there's always been a huge obstacle, which is the fact that enforced disappearances are clandestine by nature, are hidden by governments. But I would say a current major obstacle is the fact that it's a very sophisticated human rights violation, and that very few states, jurists, even victims know that this is specifically an enforced disappearance. When the working group has gone, for example, to Albania, many of the public that were interested in understanding what the working group was doing did not perceive that the deprivation of liberty by public officials during the dictatorship, followed by the denial of information with respect to the fate or whereabouts of individuals, were in fact enforced disappearances. Other current obstacles include the revisionism and negationism that unfortunately we are seeing more and more. Professor Beck referred to earlier to our session in Bosnia and Herzegovina. There's a huge tension right now in Bosnia and Herzegovina as to whether the Srebrenica genocide occurred or not, and it's being discussed in public instances, which is very, very, very worrisome, of course. On the multilateral front, the fact that the fight against terrorism is now becoming more and more normalized, and states often refer to measures adopted in this course as though it was necessary and just another measure adopted in your everyday policy adoptions initiatives. I think that's quite a problem. In particular, we have demonstrated how transnational transfers are being more and more used in total impunity, which is particularly worrisome. At the Human Rights Council, also, the alliances that we used to see, where friends of the human rights system would denounce systematically human rights violations committed by other governments in all instances, now tend to be more and more, let's say, tolerant with respect to disappearances which occur in smaller countries that fight against terrorism for larger ones in different contexts. And this tolerance, this acceptance that is very worrisome indirectly weakens the system, in my view. Current issues that the working group should or is looking into, and that the international community should have been looking into: enforced disappearances and the concept of torture. We all know that the victim of an enforced disappearance who is being detained is, of course, a victim of torture. In most cases, the relatives of the disappeared person are victims of torture, but there's a debate as to certain circumstances where they might not necessarily be victims of torture, depending on the proximity of the family relationship and network and so forth. New issues include also the role of non-state actors. In 2018, the working group adopted a specific paragraph addressing this and announcing that it would document cases related to enforced disappearances or acts tantamount to enforced disappearances committed by non-state actors. The issue of acquiescence in countries where there is systematic impunity, whether this is sufficient for acquiescence. And more recently, these current issues include the future adoption by the African Commission of Human and People's Rights of guidelines on enforced disappearances in Africa. So I participated just 2 days ago in this World Forum of the African Commission addressing the future adoption of these guidelines. And now the issues of disappearances in the context of Syria and Libya, where civil wars continue. The working group asked me to go to the Security Council, to brief the Security Council in March 2021 to address disappearances committed in the context of the Syrian conflict, and as to the pertinence, relevance of adopting or creating a special mechanism for looking for the disappeared after the conflict. So I'm going to stop with that, and perhaps we can discuss later during the question and period section. Thank you very much.
Thank you, Professor Durham. And without further ado, I would like to turn the floor into Professor Juan Pablo Alencastro. He is a member of the UN Committee on Enforced Disappearances, and he's going to talk about achievements in its first 10 years and future perspectives. So Professor Albán is a full professor of Universidad San Francisco de Quito in Ecuador in the areas of human rights and criminal law, as well as director of the clinical legal education system. He is also a graduate program professor at various Ecuadorian universities and Universidad Nacional de San Martín, Argentina. He is also one of 12 foreign experts of the Special Jurisdiction of Peace in Colombia and a member of the UN Committee on Enforced Disappearances for 2021 to 2025. Juan Pablo is also an alumnus of the International Human Rights Program here, graduated in 2003 with an LLM degree, and then is also a current JSD candidate. Please welcome Professor Albán Alencastro.
Thank you, Jean-Marc. So last but not least, I will briefly present to you what the committee has been doing in its first 10 years, and I'm grateful for the invitation that Jean-Marc sent to us, but also to have the chance to, at least through the screen, see my dear friend Bernard and Taeung. We're missing one horseman. Those familiar with football paraphernalia in Notre Dame know what I mean. So the efforts to prepare an international treaty for the protection of all people against the phenomenon of enforced disappearance started 20 years ago. In 2001, when Professor Manfred Novak, who's a very well-known scholar in international human rights law, was tasked with finding out what were the gaps in international law to protect people from enforced disappearances. He presented the report to the then Commission on Human Rights of the UN, and the Commission on Human Rights decided to start the process to adopt the treaty in 2003. The drafting of the treaty took 3 years. And the treaty is a very interesting treaty. For instance, it is the first treaty that addresses the question of the right to truth, that at the time I was here doing my master's was part of this big, discussion between Juan Mendez, who at the time was the director of the Center for Civil and Human Rights here, and Professor José Salaquet, director of the Center for Human Rights in Chile, and other scholars. They were arguing whether there was a right to truth. But now in Article 24 of the Convention, you can find the right. It is also the first treaty on human rights in the UN that does not have this periodic reports mechanism. We do have follow-ups, but we do the follow-ups concerning the aspects that the states have not been able to implement before, and we do not focus on all the obligations contained in the treaty. So I'll briefly explain the framework of the convention, and then what's the committee, and then what we have done, what they have done. I just became a part of the committee recently, and in the past 10 years, and what we are intending to do in the future. Out of the 193 member states of the UN, only 64 are parties to the convention. And that's important to point out, although at the time, South Korea, Lebanon, and Luxembourg are analyzing the possibility of ratifying the convention. They have not taken a final decision. If they do so, we will have 67 member states. We're still missing a lot of the states that are parties to the UN. 48 states are signatories to the convention, but have not ratified the convention. And 81 states have taken no action whatsoever up to this point. So that's important to point out. So the committee is a body comprised of 10 experts. We are supposed to be independent experts. We are not supposed to have any sort of relationship with the states, although we are elected by the states. And that's one of the main differences with the experts of the working group. The nomination for the working group is a direct nomination. So those interested present their own candidacy to the council, to the Human Rights Council, and the council will analyze the resume and the experience and so on, and will pick the experts to integrate the working group. And in the case of the committee, the states that are parties to the committee meet every 2 years to have general discussions, and part of those discussions every 2 years in the Assembly of State Parties is the election of 5 members. So we renew half the committee every 2 years. Now I just told you we're 10. And our main task is to support not only states, but also civil society organizations and victims in their efforts to search for the disappeared, to investigate disappearances, and to punish the perpetrators of disappearances, as well to take preventive measures in order to avoid disappearances. We are supposed to be persons of high moral character and recognized competencies in the field of human rights. It is not necessary to be a lawyer, although almost all of us are lawyers. I think 2 of the members of the committee come from the political science field, and the rest of us are lawyers. We serve for 4-year terms, and we can be re-elected once. We have this very sui generis situation right now because there's a specific provision in the convention stating that no one should serve in the committee more than 2 terms. But one of the members that was elected at the same time that I was, Mrs. Janina, she's serving her 3rd term. And she had a couple of years where she was not at the committee, and she was serving as the representative of Albania to the European Union, but after these 2 years pause, she has returned to the committee. So there's a discussion now whether, if you have this pause, you can be re-elected for additional time. It is supposed to have also a regional balance, as Taeyong explained for the working group. So you have a number of members from the European region, and you have a number of members from the Latin American region, from the GULAG. You have a number of members from Africa and so on, but we are 10 in total. And we elect a bureau every 2 years, and we have a chair. Right now is Mrs. Carmen Rosa Villa Quintana, Peruvian national. And you also are supposed to have in the bureau, in order to have this regional balance, representation of the other regions in the vice chairs. So we have 3 vice chairs, not only 1. And you also have this strange role of the rapporteur. I'm actually the rapporteur of the UN Committee on Enforced Disappearances. We're supposed to be the spokesperson, and is supposed to prepare the annual report and the final reports of each session and so on. Most of the work, intersessions, is carried out by the bureau of the committee, by of us. What are our main responsibilities? We examine state reports, and as I mentioned, we do not receive periodic reports. We receive an initial report. We raise some particular questions that concern us the most, and we follow up that after 3 years, after 6 years in some cases. And we had a recent experience before I started with the committee, where the committee decided not to set up a date for that follow-up, which is really odd. This was with 2 European countries. I'm not going to mention which of them, but this is unfair to the rest of the countries that are parties. We also can request the adoption of urgent actions by the state to search for the disappearance. So this is a Very important mechanism for us, and probably is the more frequently activated mechanism of the committee, the request of the family of the victim for us to address the government, to ask the government to search for the disappeared. And of course, our best clients, I don't know if Tayong or Bernard mentioned this, but our best clients are Mexico right now and Iraq. And we are trying to assess the situation, and I will talk about that when I refer to the fact that we can carry out this. We also receive and consider individual communications if the state has explicitly accepted the competence of the committee to do so. We can receive and consider interstate communications, meaning complaints presented by other states, but also the state has to agree explicitly to this. We can request the adoption of interim measures. These are not in order to search for the disappeared, but to protect the families. And one of the main problems that we face on the daily work that we carry out is the reprisals problem. And how states react to the fact that the families are, publicly telling that their loved ones have disappeared. We can carry out visits, and it has been in the convention since the beginning, but we're about to start our first visit after 10 years of work. This will happen next Saturday. We're traveling to Mexico, 4 of us, to do our first concrete visit. The working group has a very extensive experience with visits. We don't. So we're still trying to figure out what will happen. And the Mexican government, any Mexicans? No? Okay, so I'm not saying anything inappropriate. The Mexicans are, very tense that we're coming. They accepted our visit. We cannot go to any country unless the country accepts the visit. But they are very tense that we are not following orders. They want to take us to specific places. They want us to talk with a specific people. And we are trying to set up our own effort. And finally, in context of widespread and systematic practices of enforced disappearances, we can bring these matters to the attention of the Secretary General of the UN. I will not go, considering the time, I will not go through how the convention protects people. You're probably familiar with that, but I would like to address the milestones of the work of the committee in the first 8 years. There's actually a very interesting publication if you want to go further on this matter, that the Geneva Academy on International Humanitarian Law and the Geneva University presented on September this year, written by a former member of the committee, Mrs. Maria Clara Galvis, that is sort of a compilation of the case law of the committee on all these matters. So how disappearances should be considered an autonomous crime, how should we assess past disappearances, considering that there's a specific limitation to the work of the committee in Razione Temporis jurisdiction on whether it can receive or not information about past disappearances, what are the appropriate penalties for this crime, how to remove the jure and de facto obstacles for investigation and for the search of the disappeared and reparation, military jurisdiction and judicial independence, the duty to investigate, the duty to search for the disappeared. And there's a new discussion right now on whether there is a new right to be searched for. And this is quite interesting. This is an emerging discussion. The question of non-refoulements, access to information directed through the participation of victims in every effort of investigation and search for the disappeared, the question of reprisals, the gender dimensions of the phenomenon of enforced disappearances, because most of the victims looking for justice and trying to find their loved ones are women. And processes of data collection, registers, genetic information, data banks, and so on, and all the identification documents. And probably the most important document that we have issued in the past years is this guiding principles for the search of the disappeared, adopted in April 2019. So what are the challenges? Just a minute and a half. The question of the ratione temporis jurisdiction or competence of the committee is a quick topic, because most states, when they are going through the review of their initial reports, and later on, when they receive the urgent action notes and individual complaints, they say, you know what, you have no business here. You have nothing to do with it, because this happened before I decided to ratify the convention. But that's not necessarily the case if the convention includes several rights for the victims that actually assess the fact that if it is an ongoing situation, they do have the right to a fair and impartial investigation for the disappeared to be searched and truth, mostly the truth. So we have this ongoing discussion. We also have the discussion of enforced disappearances in the context of migration, which is probably the most notable phenomenon at the time. And we are preparing our first general comment. This is the year of the first thesis, the first general comment. And it will address the question of enforced disappearances in the context of migration, the phenomenon of children appropriation, basically the self of children, and how these can tantamount to an enforcement. The role of non-state actors, beyond what Bernard said, we are also very interested on what exactly Article 3 of the Convention, which addresses the disappearances committed by particular individuals with no support, tolerance, or acquiescence from the state. What exactly does it entail? So we are working on that, and it is very likely that we will issue a commentary or a statement on that. The question of follow-ups, how far can we go with the follow-up, considering that we are not supposed to have periodic reports, that how often can we ask the government to report to us what they are doing? And of course, the question of distance. We'll see what happens with Mexico and later on with Iraq, but we're not really sure where this will go, since we need the states to invite us or to accept our visit so we can go to the country and verify on site what's going on. And finally, the question of universalization. We have two great allies, France and Argentina. They are organizing constantly conferences of states in order to convince them to get to ratify the convention. And the goal is by 2025 to have 100 members in the treaty. Let's see where it goes. Right now, we're only at 60. And probably the greatest concern right now is the future of the treaty bodies. We meet for 4 weeks every year, twice in Geneva. That time is not enough. We do work every day in per session, at least 2-3 hours, all of us, assessing certain issues that we cannot discuss during the session, having additional meetings via Zoom and so on. And the states are not willing to increase the budget of the treaty body system. They are actually thinking on, cutting the budget. They are thinking on moving to this online sort of meeting procedure for all treaty bodies, and we are fighting to survive. There is a provision in the convention that actually stated that there was going to be a review on whether the committee was necessary and whether the committee should be suppressed. And we are trying to convince the states that we should not be suppressed, that this is a very pressing issue still, and that the committee has a lot of important contributions to do. Sorry it was so fast, but we didn't have enough time. Thank you very much.